So, good evening to everyone. Thank you so much for joining us today. We've come together for a discussion on the environment and the Indian Constitution. Just to tell you quickly about our group, we are a group of ordinary citizens who are based in Bangalore, and we're endeavoring to engage deeply with the Indian Constitution with the larger goal of building better societal understanding of people's constitutional rights. We've been organizing a series of these talks on the Indian Constitution to increase citizen engagement with it. And through our sessions so far, we've analyzed the Indian Constitution as a product of struggle, a struggle which has been political, social, and economic. Gradually, we saw how law in itself is a product of struggle. And in our previous sessions, we've seen how the National Rural Employment Guarantee Act, the right to food, or the right to information, for instance, were born out of struggle. And we feel that one could argue that a lot of the content of environmental governance in India today was inspired from people's movements to safeguard the environment, apart from, of course, its grounding in judicial precedents. We're living in times where the government is looking to alter environmental laws and norms that may prove detrimental. And we thought it's important for us to reacquaint ourselves with the constitutional framework vis-a-vis the environment so that our struggles to protect the environment can be well informed. And that's why we've assembled here today. It's for this reason that we also have Mr. Abhayraj Naik, who will be our speaker for today. He's a lawyer and educator who has co-founded the Initiative for Climate Action. He's also a visiting faculty at the Azim Premji University, as you may have gathered by now, and teaches an elective course titled Climate Justice in India. We're very, very happy to have you with us. A warm welcome to you, Abhayraj Naik. Before I hand it over to him, just a few housekeeping rules. Kindly keep your audios and videos on mute at all times. Please change your display names to your actual names so that we will be sure of who is logged in. And should you have any questions, please feel free to type them into the chat box as and when you think of them, and we'll take that up during our Q&A session. With that, I think we're ready to begin. So over to you, Abhayraj.
Thanks very much, Purna. Good afternoon, everyone. Thank you for being here. I'm quite delighted to have an opportunity to get into a conversation with you around a topic that's very dear to my heart, and one that I consider myself to very much be a learner of and a student in the investigation of. So this conversation has given me the opportunity to attempt to gather some of my thoughts and think of a good way to present this to a mixed audience who is interested in understanding and using the Indian Constitution and related to struggles around the environment. So before we get into anything substantive, I'd like to give you a sense of my own approach to this session. I think I would be delighted if we spend a maximum of time on questions and on dialogue and conversation rather than me intoning on and having a rather one-way broadcast. I do hope to give you a sense of the conceptual, the legal, the historical, and the philosophical terrain of environmental rights, environmental issues more broadly, and the Indian Constitution. And the method of inquiry that I'm adopting is not that of a lawyer as much as a constitutional ethnographer. And what I mean by that is I'm interested in sort of using particular moments or particular artifacts of our constitutional history to uncover more hidden, deeper processes that implicate different kinds of people and different contexts of power as part of a longer historical process of interaction. So my inquiry, my comments are sort of coming from how a constitutional ethnographer might approach this question of thinking about environmental rights in the Constitution. The sort of concept of constitutional ethnography itself has been, I think, quite usefully articulated by a scholar called Kim Lane Chappell, and a professor of anthropology at the Yale School of Forestry and Environmental Sciences called, goes by the name of K. Sivaramakrishnan, has also adopted this approach on a topic that's pretty similar to what we are interested in through an article called Law, Environment and Democracy that was published in about 2011 or 2012. He attempted what I think is the only one of its kind, a constitutional ethnography in the context of environment and India. So before we move forward, I would like to sort of, with the permission of Pura and other organizers, perform a little bit of an organizational function. I would sort of encourage you to just ground yourself slightly for a good session that we can have together. And I'm cognizant that it's been a Sunday, so folks have been doing the full range of things from absolutely nothing to recovering from the trauma of a busy week to preparing furiously for the week ahead. And that said, your mind might be in many different places based on what has happened earlier today, what has happened over the course of the week, and what you're expecting of the week ahead. So to get us started, I just invite you to join me in sort of being fully present here. And as I said, I'm hoping for a participatory session that we sort of co-create. And if you feel comfortable, I'll invite you to close your eyes or sort of lower your gaze, keep your back straight, and just sort of let your mind return to your body. Maybe take stock of and note where your feet are touching the ground that's common to all of us and to all life on Earth. Also use the opportunity to sort of just focus on your breathing, and while I'm sure thoughts might be coming to you, just let them come and let them go. Just stay with your breathing and your body. Recognize that, again, the air that we are breathing is common to us wherever we might be. And use this brief interlude. I promise it's just a minute or so. I know you have not come here for a meditation session. Use the interlude to just take track of what's going on in your body. You know, it's the greatest instrument you possess, and see if you're carrying tension or tightness or pain somewhere within it. You could even scan from the top of your head through your face and neck and shoulders and chest and arms to your stomach, your pelvic area, your upper legs, and to your feet, and just say hello, particularly to parts of you that might be carrying more tension than normal. And after a couple of more deep breaths, when you feel ready, open your eyes and be fully present here. So let's get started with, and again, I'll invite you to take 30 seconds or 60 seconds and think about this. But let's get started with an effort at populating our chat box. I hope Purna, everyone can access the chat box here. I'll just invite you all to think of this. We're here to talk about environment and the Constitution. What would you like from this session? What would you feel happy with at the end of this session? If you want to just put down a few words to that effect in the chat box, take a few seconds to think about it as well. And that will help me sort of orient my comments in a way that might be useful for you. I can't promise you that like the genie, I'll give you what you want, but I can try. That is the intention and motivation here. So I'll invite you to just type out a few words on what you'd like from a session on the environment and the Indian Constitution today. Anyone willing to get us started off? Otherwise, it looks like a forlorn chat box. Thank you, Kusuma, for getting us started. Thank you, Mridula. Thank you, Shaili. Thank you, Kajal. Concrete solutions. That's, yeah, I can understand. That's important. That's what we are all looking for. Okay, so just to give you a sense of what's already been added to the chat box, and maybe just half a minute more for other folks who want to come in. Okay, the constitutional promises about environmental protection, how the environment has been read into the Constitution, a historical overview, something about how the environment and the right to life are connected or might be understood, concrete solutions. Okay, so Kusuma continues. A lot of constitutional promises, but how in reality the protection of the environment takes a backseat. So maybe some reflection on that or what we could do. Broad history from Janaki. Hi Janaki, how are you doing? Good to see you in an environmental context today.
Hi, Abhay. Looking forward to the session.
Thank you. Vivek, apart from directive principles, what specific provisions are there to protect the environment, such as what laws can be considered illegal and overturned? Ramakash, can Article 21 and the directive principles of state policy help us challenge policy decisions of the government with regard to the environment in the context of climate change litigation? Namrata, hi Namrata, nice to see you as well. How can we have a stronger constitutional mechanism that prevents sub-legislations like the draft EIA 2020? Mridula, recent important environmental judgments. And what specific actions can I indulge in to prevent destruction of our environment? How can I lean on the Constitution for support? Super. Thank you. Thanks very much for all of y'all for participating, and let's see how many of those we can get to and sort of think about together. I think it's a great set of inputs, and I find it very, very useful to think of the range of comments that might be useful for this audience. So I'm going to share my screen with you and sort of take us through a mini presentation to, in some ways, set a structure for a discussion on the environment and the Indian Constitution. And sort of someone mentioned climate change as a concern. This is a photograph that every time I'm giving a talk or taking a class on climate change, I find it particularly useful to use this photograph with an audience, simply because of the sort of affective zone that this sort of helps bring into our thinking, right? And you see a number of things happening. Firstly, of course, the photographer is obviously someone with skill, given how he's or she's framed this and found a moment where the water is really flowing down from the steel vessel into the earthen pot. Other things that I think of when I see this photo are firstly the cracked nature of that soil. Okay, that obviously shows you parched earth. It shows you that this is a geography that is not one where water is plentifully available in the soil. The very act that this young woman, girl is engaged in of in some ways collecting water and saving it seems to suggest a scarcity of some sort. There's desperation, there's tenacity. It reminds me also of a lot of discussion that happens in the world of international development and SDG, Sustainable Development Goal conversations, where there's sort of very well documented evidence of how a 10-minute or 15-minute increase in the time taken to collect water, and there are sort of national and supranational studies, mostly in the African context, that have been carried out. A 15-minute increase in the time to collect water results in almost a 40% decrease in girls' enrollment rates in school, right? And all of those thoughts come to my mind when I think about this, and that's the spirit in which I'd like to think of both rights and the Constitution today, not as conceptual, artificial, philosophical, or jurisprudential constructs, but as resources and pathways, constituents of our sense-making apparatus in ways that are very, very real to what we encounter as flesh and blood individuals, right? And that's in consonance with my broader approach to law, part of my approach to law and society, or part of my belonging to the law and society tradition of legal research and scholarship as well. So let me start off with, even before I get into the Constitution, let me try and share with you what I think is a particularly useful way to structure an investigation or an inquiry into the relationship between environmental claims and rights. And I borrow from the work of one of the most sort of erudite and distinguished environmental historians I've had the privilege to read. This is Ravi Rajan, who teaches at the University of California in San Diego. I think he's the head of the Greenpeace International Board as well. Has written beautifully on environmental history, including environmental history in India, and his essay on the history of environmental justice in India is a sort of resource that I use without fail every time I'm offering a course on environmental justice and climate justice. Anyway, the piece that I found useful to refer to today, and I'm going to share with you the essential takeaway from that piece, was a piece that sort of came up with a taxonomy, if you wish, or a categorization of the different ways to think about environmental claims and human rights frameworks, right? And I think in this audience, and more generally for progressives who are interested in constitutional discussions, the Constitution is a paradigmatic human rights framework, right? It is both a legal and a political framework that really has human rights at its heart and soul, depending on how you view the Constitution. And Rajan and colleagues take us through 5 categories, the first of which is the use of, just give me a sec, these video thingies are impeding my own ability to see what I have up on the screen. Yeah, the first category is where we sort of make the connection between rights and environment by using human rights as they have traditionally been intended. But we use existing human rights with the purpose of protecting the environment from degradation. So these traditional human rights, many of which you'll be quite familiar with, just if even when we read newspapers, we have a sense of what are the human rights that most often come into play in democratic contexts. Uh, these would include largely procedural rights, that is, a right to have information about activities that have environmental effects, the right to have to participate in environmental decision making, and the right to have access to remedies, which would be, let's say, the right to go to a court and ask a court for some kind of legal remedy when an environmental harm has occurred, right? And someone mentioned the draft environmental impact assessment notification of 2020 that has been in the eye of the storm in recent times, not least because of the rather uh, authoritarian fashion in which the ruling government has attempted to railroad this through. And with the environment impact assessment notification of 2020, uh, we see each of these, at least the first two, the right to have information about activities that have environmental effects. Okay, maybe not even that one. Public participation in environmental decision making. That right, people argue, is attenuated by the new draft environment impact assessment notification, right? Because the notification removes some projects from the requirement of having a public hearing, a requirement that was there under the earlier environment impact assessment law of 2006, which continues to be in force. And uh, when people get angry with that, they are coming from a place where they believe, both morally and legally, that they have a right to actually participate in a decision that has an impact on the environment around them, right? So I think many of you all are also from Bangalore today. Uh, what is happening with the peripheral ring road, where uh, very recently 2 students from the Jindal Global Law School and 1 student from the National Law University, Delhi, they went to the Karnataka High Court and they said that a peripheral ring road is being built in around Bangalore. The Supreme Court has already earlier pointed out the problematic nature of this ring road and has insisted that it comply with all kinds of procedural requirements. And lo and behold, the government of Karnataka is having a public hearing for this ring road on Zoom. And we are not able to participate on a Zoom public hearing. We think that our ability to participate is affected by the fact that it's being organized on Zoom, right? So that is a usual democratic right, like the right you in a non-environmental context would also invoke. For example, when demonetization occurred, part of the rage that was seen in India was about how no one had been told about it, no one had accepted such a drastic change, and our ability to participate had been impeded, right? Similar with what happened in Kashmir as well. The first one, the right to have information about activities that have environmental effects, is also connected to the environment impact assessment notification, right? And this right is seen most strongly in the context of the invocation of this right is seen most strongly in the context of military and defense projects, which usually claim that they are not within the purview of even the Right to Information Act of 2005, right? Most other most other public authorities or projects from the government would in some way fall within the sway of the Right to Information Act. But in the context of military or defense projects, which the latest EIA draft has expanded to all projects that the national government deems as having strategic importance, uh, the project proponent is not even required to share information, right? And this again is an example of a traditional human right being applied to an environmental context. So let me just pause there. Anyone has any major conceptual confusion with this first way of thinking about environment and human rights? It is just the using of existing human rights, your right to participate, your right to associate, your right to expression, your right to information in the context of an environmental issue, right? So it's nothing particularly creative or new. It is an instrumental or a purposive application of existing human rights for an environmental purpose. The second way of thinking about human rights and environment is to, and please pay attention to this because this is where most of India's constitutional environmental rights have located themselves, is to expand existing human rights to enable them to better address environmental harm that interferes with the enjoyment of these rights, right? And this is what is typically referred to as greening existing human rights law. So the right to life, the right to health, the right to food, the right to water, the right to sanitation, the right to a decent or adequate standard of living, the right to culture. And all of these are rights, if not under the Indian Constitution, are rights that have been recognized under our seminal international human rights instruments, most notably the Universal Declaration on Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights, right? And this approach or method is to take an existing human right and expand its scope such that environmental concerns are also included within it. And to ruin the suspense of a possible later story that I might choose to share on the Indian Constitution, this is what the Supreme Court has done from the late 80s all the way to the present in the context of environmental public interest litigations. It has reinterpreted or expanded the scope of Article 21 in the Constitution of India. Article 21, which reads, "No person shall be deprived of life or liberty except according to procedure established by law." And that is a bit of a confusing format of drafting. It's more colloquially referred to as the right to life in the Indian Constitution, which I'm sure many of you all are already familiar with. And the right to life in India has been interpreted by the Supreme Court in numerous decisions, okay, to include, firstly, as you might know, Justice Bhagwati in the Bandhwa Mukti Morcha case, which was a case that didn't concern environment, concerned more the condition of migrants and workers, said that the right to life means the right to a dignified life. And with that first move, right to life means right to a dignified life. In another case, famously, the Supreme Court has said that the right to life is not a mere animal life. The finer graces of life, including that which dignified living requires, are included in the Article 21 guarantee of a right to life. And the Supreme Court expanded that right to a dignified life to mean the right to pollution-free air and water, the right to broadly environmental protection, the right to sanitation, the right to adequate information about environmental harms, right? And that continues to be the place in the Indian Constitution where environmental rights are most visibly present. Because if I have to carry out a quantified statistical analysis of Supreme Court and High Court decisions on the environment in India, all of them that refer to the Constitution, or 90% of them that refer to the Constitution and rights, will invoke Article 21, right to life, to include environmental rights, right? And the right to life has also been interpreted by the courts as including a healthy environment. So it's included a safe environment, a healthy environment, a pollution-free environment, clean air and water, and finally, information about the environment as well. Okay, so let me stop there again. Anyone with any strong difficulty on this point? Just, we're still at an early stage, and I'll hopefully layer it several times over. But the first method was use existing human rights to further environmental purposes. The second one is expand existing human rights to include environmental interests or claims within them. Yeah, and you should feel free to unmute and just jump in if you have especially a confusion. That's I think best addressed on the spot. If it's a general comment, maybe as soon as I conclude, we can sort of address all comments and questions. Okay, so let me proceed to the next approach. The third approach is to recognize a new separate human right to a healthy or quality environment. And this was first recognized in the Stockholm Declaration of 1972. Okay, this 1972 and Stockholm are really important for India and environment as well, because this is where Indira Gandhi went and gave her famous speech at Stockholm. And in a sense, what happened at Stockholm and the fact that Indira Gandhi became a bit of a celebrity for her passionate speech at Stockholm catalyzed many developments when it came to both constitutional amendments and statutes or legislations, non-constitutional, but nonetheless acts of parliament at the national level, including some acts of the legislature at the state level in the immediate aftermath of Stockholm. Anyway, the point that Rajan and co are pointing out here is that the third approach to connect human rights and environment is to actually declare a human right, a separate human right. And that's the key point. It's a new or separate human right. It's not read into an existing human right of life or food or culture or heritage, etc. And such rights have, since the Stockholm Declaration, been increasingly recognized in domestic laws and constitutions. And they have been receiving a lot of attention from the inter-American legal system, the United Nations system, etc., etc. The point to note here, because I'm just to prevent me speaking at you or to you for too long, I'm just stitching together the India relevance bit as well. India does not have a separate human right to a healthy environment. Like the right to education, as you know, was introduced into the constitution, right? And like the right to equality in Article 14 was always a part of the constitution, and your right to free speech and expression, Article 19(1)(a), or your right to freely travel through the territory of India, 19(1)(d), if I'm not mistaken, your right to reside in any part of India. Those are, sorry, did someone say something?
No, I think it was just a connection problem. You can carry on.
Sure. So in that sense, there continues not to be a distinct environmental right in India, and it's interesting to note that one of India's older and more prominent environmental NGOs, the Foundation for Ecological Security, along with supported by organizations such as Kalpavriksha, etc., uh, had, as almost 15 years back, launched a campaign for the declaration of a separate environmental right. And it continues to be something that those who are interested in transformative constitutionalism would be interested in. I personally continue to think that it would be good to have a self-contained, new and separate constitutional right to a wholesome, healthy and protected environment instead of reading it into the Article 21 right to life. Okay, so let me move to the fourth method of using human rights for environmental protection. And this is, in a sense, where we are getting into territory that traditional human rights scholarship finds itself, or even traditional constitutional theory finds itself a little sort of confused by, right? Which is arguing for new rights for the environment itself, what are commonly referred to as rights of nature. Another way in which the distinction between human rights and rights of nature are pointed out is by pointing out how human rights, it's almost obvious, human rights are anthropocentric. They are premised on human beings be the starting point and the ending point for any conversation on rights. Whereas rights for nature come from discourses of ecocentrism, of deep ecology, of biocentric egalitarianism, of interspecies equality, right? Uh, they are non-anthropocentric in that sense. The other distinction is between thinking of the environment only in instrumental terms. That mango tree that I can see outside my window is important because it keeps the air here slightly cooler and it occasionally gives me mangoes, though it's not been giving me mangoes for a long time. I don't know what's up with it. Or that mango tree is important because it is life like me. It is as complex and beautiful and uh, uh, worthy of respect and importance as I am, right? And that's the difference between an instrumental and an intrinsic approach. So a famous conference on the rights for nature in Cochabamba uh, is often referred to while talking about the rights for nature movement, and in particular the constitutions of Ecuador and Bolivia, which in the constitution itself guarantee rights for Pachamama or the mother goddess, are often hailed as classic examples of the rights for nature movement. Now this is important because I suggest that we are at a transitional moment in Indian environmental constitution, in Indian environmental constitutionalism, and it's a moment that began roughly in 2012 and is still unfolding, so it's not ended, where we are seeing openings for rights for nature in the Indian constitution itself. And this is mostly through the absolutely phenomenal judgments in the Supreme Court of Justice Radhakrishnan, starting with a case known as the Chhattisgarh wild buffalo case, 2012, a red sappers case, which is on red sandalwood, again 2012, the famous Niyamgiri judgment, which many of us might be familiar with, which prevented Vedanta from expanding its bauxite mining in Odisha, 2013, and the more recent Jallikattu judgment, which continues to be quite controversial. Okay, all judgments that were authored by Justice Radhakrishnan, and no wonder also the famous Gir line judgment, where Justice Radhakrishnan sort of struck down or refused to accept the Gujarat government's argument that the lines, the Gir lines were a part of the Gujarati family and should not be therefore taken to Madhya Pradesh to enable their sort of preservation in more than one area in case some kind of disease struck, right? In all of these cases, Justice Radhakrishnan has introduced rights for nature into India. Okay, he's not done it surgically, he's not even done it beautifully, he's done it in a messy fashion, but he has done it, and that's my argument. And sort of high courts, including the Uttarakhand High Court and the Punjab and Haryana High Court, have picked this up and have declared rights for the Ganga, the Yamuna, for all members of the animal kingdom. Sukna Lake in Chandigarh now has rights, right? Even the Gangotri and Yamunotri glaciers have rights. So, as I suggest, things are in flux, but this slightly creative way of connecting environment and rights has found its opening in India. And thankfully, thanks to what who I think of as a visionary Indian Supreme Court judge, it has been firmly lodged. It's not just some random one-off judgment. It's a series of judgments that have recognized rights for non-human life in India. The fifth and final approach or method, and this is very similar to the fourth approach, is where you're not really focused on the rights of nature as much as you're focused on the corresponding duties or responsibilities that must be discharged for that right to actually be something that manifests or something that is respected or realized, right? For all the non-lawyers, one of the most celebrated conceptual thinkers in the English-speaking world when it comes to the conceptual analysis of law is a gentleman called Wesley Newcomb Hoffeld, who basically said you can really get into the DNA of any complicated social reality by understanding the core legal or jural concepts around which that reality is constituted. And the idea that he introduced, the idea of jural correlatives, says that for every right, there is a corresponding duty, right? And I mean, I'm reminded, since we just passed through Mahatma Gandhi's centenary or 150th birth celebrations recently, Gandhiji is famous for saying that, you know, I don't think of my rights as much as I think of my duties. And once I think of my duties, I realize that I have more rights than anyone I know, which is a bit of a vague sentence for an English-trained lawyer, but he is speaking in the language of correlatives, where thinking of a right and a duty as a pair is a more is a deeper way of understanding what's going on at the legal end, which is somewhere beneath the messy social epiphenomena that we all see. So there is someone's right, there is also someone's duty. And Hoffel pointed out that rights, duties, powers, liabilities, immunities Okay, these are some of his fundamental concepts. They're usually working as correlative pairs and as opposite pairs. So coming back to my point here, the fifth way to, hi, someone is, I think, not on mute. So I'll just request you to keep yourself on mute, unless you want to jump in and clarify or, so the fifth way to think about the relationship between rights and the environment would be to not emphasize the right as much as emphasize the duty of someone who, by doing that duty, will in some way protect an environmental good. And arguably what the judge of the Uttarakhand High Court has done is more than thinking of the rights of the Ganga and the Yamuna, he was interested in getting the chief secretary of Uttarakhand along with one famous person from an NGO, etc., etc. He wanted them to have duties of taking care of the Ganga and the Yamuna, right? The rights bit, I mean, he said that they have rights, but he was more interested in giving duties to these guardians of the rivers. And as you might realize, 4 and 5, the rights for nature and the duty, elaboration of duties which will result in the protection of nature are very neighboring methods. Quite often they work next to each other. So coming to the Indian Constitution now, and I'm just going to pick up pace so we can, I can actually stop speaking and we can get into questions and dialogue. I think it's useful to talk about the Indian Constitution and environmental rights in and through 5 broad meta level points, right? One would be, I would urge folks to locate the Indian Constitution, especially the Constitution from the 1947-1950 period, not at the start of a journey, but as another disruption in a longer canvas that included British law in India, right? And just to give you a sense of why 1947-50 is in the environmental space at least, is not the start of law, but is just another punctuation mark, if you wish. But for us, citizens of the Republic of India, the most important punctuation mark, if all of the marks might be considered as law in our social reality. A scholar like Chhatrapati Singh pointed out that at the end of the 19th century, 80% of forests in India, natural forests in India, had some kind of common property system of governance. They were not privatized, or they were not, in that sense, regular people were not blocked from accessing 80% of the natural forests in India, right? But when the English were ruling this country or this territory, there was a need to really bring forests under private ownership or straight off take control of them as the colonial power. Not least because villages and forest dependent settlements were not a useful way, were not proving to be good taxpayers or revenue givers to the English. It made much better sense to extract a good revenue and tax from slightly more identifiable landowners, right? And so the history of British law in the context of forests and more broadly natural resources in India is one that is characterized as one where the natural resources of India were bought under a system of scientific management so as to be utilized for the colonial empire, for the interests of the colonial empire. And your classic story is of forests being chopped down to create railway track, the planks that we see, I don't know what the specific term is, to build the railway lines in that sense. And the Constitution of India didn't necessarily change that. These laws, including, you should know that the Indian Forest Act dates back to 1927. These laws passed through the Constitution of India and continue to operate in independent India. And so the Indian Constitution and Indian law and Indian approaches to or approaches to rights in the context of environment in this territory that is now known as India would have to have a slightly longue durée historical approach. Where the scientific management and command and control technique of the English when it came to natural resources continue to play out, and they actually passed through the gate of the Constitution and continue to operate in independent India. The other point to note is that the English also sort of created the prototypes of what are our present day national parks and sanctuaries, right? So the existing even the what we call the Jim Corbett National Park was actually created under British law a long time back, right? So while at the one level the English were keen to exploit and to scientifically manage and to extract revenue from and to destroy old common property forms of governance, they also, especially when it came to conservation of animals, they also created protected enclaves or fortresses that also have passed through into independent India, right? And when Purna asked me, or rather when Purna told me that some discussion had been had on the Constituent Assembly debates, etc., it would be good to think about the Constituent Assembly debates in the context of the environment. My first reaction was there were no Constituent Assembly debates on the environment. At least what little I have read, I have not seen anything on the environment, right? And it took some digging around, and the classic historians would be maybe Mahesh Rangarajan, Shivarao, of course, the core documents, also someone like Sivrama Krishnan, who I mentioned earlier. Once you actually look for writing or scholarship that explores Constituent Assembly debates and environmental protection and environmental rights, some people just say there was nothing. Everything came only in the 1970s after the Stockholm Conference, which I'm going to get to. A few other more nuanced commentators point out that the real discussion in the Constituent Assembly debates on environmental matters came down to a federal discussion where environmental questions were folded into a federal debate on is it the national government or the state government who has control over forests, water, air, sanitation, so on and so forth, right? And the point that I have gleaned, and I must tell you, I'm not an expert yet. I'm still just starting my journey on understanding the early constitutional history of environment in India, and I'd be delighted to learn from someone who might know more on this topic. The early division of powers seems to be that with the exception of interstate rivers, a lot of environmental aspects, particularly forests, but also sanitation, so on and so forth, became the legislative purview of the state, right? You might be familiar that under the Constitution, there is a 7th schedule which has 3 lists, list 1, list 2, and list 3. Each list has a number of items listed out, okay? It could be, so list 1 begins with the defense of India, right? Includes almost 90 plus 97 entries, right? And the central legislature is entitled to pass laws on items here. List 2, the state list, which begins with public order, but not including use of military force, has about 66 entries and falls within the legislative purview of the state. And finally, list 3, the concurrent list, which is a very important list for everyone who's interested in environment and the constitution, has about 47 entries, okay, beginning with criminal law, which both the central legislature and the state legislature can legislate on. So initially it seemed like most of the environmental stuff fell within the state list as such. And the only discussions on environmentalism that we can trace to these early years of constitution making seems to be on the federalism question. Otherwise, the Government of India Act of 1935, which, as many of you know, is the forerunner of the Indian Constitution. We borrowed from there, we borrowed from the Irish Constitution, we came up with a few of our own special items of relevance, and we created the sort of magnificent edifice that is the Indian Constitution. So the first 2 years mostly saw environment, and there is no constitutional point here, but there is a recognition of what was going on in the economy and society and the polity. The decades of the 50s and 60s mostly continued with this imagination, what is an imperial imagination, or comes from an imperial imagination, where all forests, all water bodies, all fowl and all plants are for the national interest, and you can do what you wish with them is the unstated part, right? And thinking about dams as the temples of modern India, those kinds of sentences, etc., is useful in that context. Now, the real constitutional action began after the 1972 Stockholm Conference, right? Which is when a bunch of amendments were introduced into the Indian Constitution that were very specifically environment focused, right? Number one, 3 items came up in the concurrent list, right? Forests moved to the concurrent list, if I'm not mistaken. Wildlife got introduced, and animals and protection of animals, prevention of cruelty to animals got introduced into the concurrent list. Most significantly, a chapter on fundamental duties or an amendment on fundamental duties made it a duty of every Indian citizen to protect and preserve the environment, right? Finally, a directive principle of state policy, which initially were sort of policy guidelines for the Indian government, but subsequently through an interpretation of courts have occasionally become enforceable. They're not just guidelines, but they've resulted in courts actually reading enforceable rights even from the directive principles. A directive principle was introduced which said that the state shall direct its policy so as to protect and preserve the environment, right? Including wildlife, forests, and lakes, etc. On coming back to the fundamental duty, it was in the 70s that what is perhaps the most unique duty in any constitution was introduced, which is a duty of every citizen of India to have compassion for all living beings. Okay, that was introduced as well. Around the same time, and these are usually lesser explored in discussions on the environment, a number of directive principles starting from Article 39 of the Constitution, okay, that have relevance to environmental issues, right? 39B, for example, the state shall in particular direct its policy towards securing that the ownership and control of the material resources of the community are so distributed as best to subserve the common good, right? And I will have to go back and check the periodicity of each of the directive principles, but most of the environment-specific ones seem to have been introduced by the 42nd Amendment Act in 1976. And I am quite curious about the specific circumstances that resulted in this. I know broadly it is the post-Stockholm euphoria and a recognition from the international level that environmental rights and environmental consciousness were important, to also Indira Gandhi, who Rangarajan in his biography or his description of her has pointed out as someone who loved wildlife. It could have been her own sort of personal motivations, but Article 48A, the state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country, right? And finally, Article 51AG, the fundamental duty I mentioned, to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures, right? So fundamental duties are still difficult to get enforced by a court. And even if you go to a policeman and say that person is not following his fundamental duty, that won't cut much ice. But directive principles, getting them enforced, definitely has a good history, especially over the last 20 years of decision making by the Indian Supreme Court, right? And quite often in cases, judges do rely on directive principles, but usually prefer to stay on the most solid footing of a fundamental right. So you do have a directive principle which basically says the state shall protect the environment. You do have a directive principle which basically says the state shall ensure that the material resources shall be so distributed as to subserve the common good, right? So that's what happened in the immediate aftermath of Stockholm. This was around the time when also environment came into the 5-year plans. Actually, they came into our 5-year plans even slightly prior to the Stockholm conference. In the 70s, under the Department of Science and Technology, a committee was set up which looked at planning and environment. That was the earlier forerunner of what is now the Ministry of Environment and Forest. The hazardous waste rules that were introduced in the late 1980s were the first ones that had environment impact assessment included within them. And as you know, the terrible Bhopal tragedy precipitated an umbrella legislation called the Environment Protection Act of 1986, right? So the period immediately following the Stockholm Conference from 1972 began to see not only amendments relating to the environment coming into the Indian Constitution, but also a plethora of new environmental legislations being passed, which takes us to environment public interest litigations, right? The PIL began late 70s, early 80s with more traditional human rights categories such as prisoners, bonded laborers, police torture, etc., right? But it soon moved to environmental issues, and the later half of the 80s were incredibly focused on environmental litigation. This is the period where what are considered to be paradigmatic environmental cases of India, you know, the rural litigation entitlement Kendra case, the Dahanu Valley case, the Bichri case, which is S. Jagannath versus Union of India, where the government is directed to come up with a coastal regulation protection, even extending to MC Mehta's cases, where tanneries in Kanpur asked not to pollute into the Ganga, the Professor M.V. Naidu case, where a precautionary approach the Vellore Citizens Forum case, where again a precautionary approach, the Ganesh Wood Products case, where the principle of intergenerational equity is recognized, right? The late 80s, early 90s, explosion of environmental litigation. Every Friday, the Supreme Court is devoting to environmental PILs, to the extent that by 2010, Mondays and Fridays are going for environmental litigations at the Supreme Court. So it is only over the last 10 years that the tap of environmental PILs has been turned off. But from the late 80s, stretching till 10 years back, environmental PILs really dominated the docket of the Supreme Court and the High Courts of India. And the cumulative value of all of these PILs is, number one, as I mentioned, you have a right to a healthy, safe, pollution-free environment as part of your fundamental right under Article 21. That's the most important thing to register. You also have the recognition by the court that certain principles of international environmental law, like the precautionary principle, which basically says if you're not sure of what harm will result from a particular activity, don't carry out that activity, in simple terms. Or the polluter pays principle, which is the person who polluted something should pay for its cleaning up, arguably even for compensation resulting therefrom. The principle of intergenerational equity, which is unborn future generations also have rights that the law must protect. The principle of prior and informed consent, right? You can't do something that affects the rights of people, especially communities dependent on forests, without their prior and informed consent, right? And the principle of sustainable development, which was directly taken in from UN discourse, were all considered to be a part of Indian law, along with the public trust doctrine, which is an important doctrine for all of y'all potential activists to remember, which is a principle that comes to us from property law, from English property law. It's the common law of property, which basically was innovated by American courts to mean to hold that the state holds all of nature in trust for the public. So it's not that the state controls our coastlines, our lakes, our air, our animals, to do what it wishes with them. It is a trustee, and trustees, as you know, under law, have particularly onerous obligations towards their beneficiaries, right? So the state holds all of natural resources as a public trustee. And this was a famous decision in the MC Mehta case, where the famous politician Kamal Nath was involved in where the river Bias had its course diverted by a hotel being built. And the Supreme Court stepped in and said, no can do. The river and all of the land around the river is held in trust by the state, and you can't just do what you wish to the damage of the environment. So I'm really going on for longer than I wish to. So what have been the paradigmatic legislations that anyone interested in environment and constitution would take note of? I would say two, and I'll just choose the two most important ones. One, the Forest Conservation Act of 1980. Two, the Forest Rights Act of 2006. Maybe I'll make it three. And three, not a legislation, but a couple of delegated legislations. The first in 1994, the second in 2006, and the third and most recent one in 2020, which have been on environment impact assessment norms, right? These are non-constitutional, but in a country such as India, it's important to read the constitution as flowing along with statutes, with case law, and with political decision making, right? That is how the normativity of this country is constituted. So the Forest Conservation Act was passed to take away forests from the state in a sense, and to require permission from the Ministry of Environment and Forest if any state was diverting uh, forest land for non-forest purposes. So decision making relating to forests got centralized. And that was happening because in some states, forests were being sold by corrupt state governments. And the Forest Conservation Act is the legislation around which probably the most famous Supreme Court case, the Godavarman Tirumulpad case, what is called the Forest Conservation case, where the Supreme Court basically became the policy maker, administrator, implementer. It did all the roles. It set up new committees. All kinds of new hybrid spaces were created as well, relating to the use of forests, especially for non-forest purposes. The Forest Rights Act, which deserves a separate session by itself, which speaks very much to Purna's point from early on today, right? The product of constant mobilization. And the Forest Rights Act is beautiful because it allows me to also make the point that environmental rights in India are both individual rights. I have an individual right to clean air, and community rights. We as a forest dependent community have a right to say no to this project that wants to mine our hill for bauxite. The Niyamgiri judgment, or the earlier more famous Banwasi Seva Ashram judgment from the heyday of the Supreme Court in the late 80s. We as forest dependent communities have a right to participate in the environmental decision making that affects our forest. So the rights are both individual, my right to free air is being affected, and community rights. You trying to mine our hill for bauxite affects our community's right to pray to our God who lives in that hill, which is what the Dongriya Kon tribal said in the Niyamgiri case. And finally, the new era of transformative constitutionalism, I won't spend more time on this, I spoke about this, right, which is particularly through Justice Radhakrishnan's visionary efforts, starting from 2012, you are seeing a nascent rights for nature moment in Indian constitutionalism. And part of the work I do, I think Namrata, who's on call, is a colleague as well. There's a new collective that is fighting for rights for rivers in South Asia, right? Animal rights are increasingly being taken to court, and they were recognized as constitutional rights in the Jallikattu case. Though without a clear constitutional provision, Justice Radhakrishnan really struggled to connect the animal rights to the human right to life under Article 21. But he did it. He did it in an odd way, and he did it in a way that will not stand up to careful logical scrutiny, but he did it nonetheless because he knew that's what he needed to do. So theoretically, he couldn't achieve it, but for practical purposes, that is an authority for all animals having these fundamental freedoms under Indian law as well. And judges, including the Uttarakhand High Court justice, are now declaring more and more natural objects as possessing rights, right? And I personally think this is a very promising pathway. It'll require a lot of work. Who will protect the rights that nature has? Who will speak on behalf of nature? What is a violation of a right? How do these cases come to court? But across the world, including in jurisdictions such as Colombia, Australia, New Zealand, very innovative mechanisms have been set up where communities who are most closely connected with the nature in question become the voice and the guardians of that nature or environment, right? The flip side is sometimes, and this gets me sometimes into conflict with the human rights folks who are not as interested in environment as I am, where we should also recognize that sometimes communities have caused devastation of nature, right? I believe so, and I would be happy to furnish some cases that where this has been the case. So rather than a one-size-fits-all approach, I guess each context will require an institutional governance framework that respects the rights for nature in that context, right? So that said, generally, I am partial towards the community rather than the forest department or the government having control. So those are 5 key ways in which I'd read the story of the Indian Constitution. These are just some pictures of the judgments I mentioned, okay? In this case, Article 25 and Article 26 of the Constitution, which are rights to religious freedom, were creatively used to protect a forested mountain from bauxite mining. This is a case from Bangalore, which I was involved with my former workplace, the Environment Support Group, where through our litigation, we effectively shut down an illegal landfill, and we hugely reduced Bangalore's toxic waste that was going to a largely Dalit inhabited village called Mavali Pura, which is in Yelahanka. You can drive there from wherever you are. In Bangalore. We worked with the Dalit Sangharsh Samiti closely, and we, in our petition, invoked constitutional rights to equality under Article 14 and 15, the right to a healthy environment under Article 21, and the right to live freely throughout the territory of India, right? This village was established well before Bangalore chose to dump its waste there. And we got the Karnataka High Court to more or less shut down the landfill. In recent times, I've discovered that some dumping is still happening. And unfortunately, the people there continue to suffer the toxic legacy of well-heeled Bangaloreans' waste, cancer, and other kinds of health, other kinds of diseases are continue to be rampant there. It's a live case of environmental injustice, but the Constitution provided some help. It stopped the continuing toxic pollution. Now, I think the next level of reparations and compensation, etc., should be explored. And finally, a case that I'm involved with right now, where on a very narrow ground, we've gone to the Karnataka High Court, questioning one of the conditions in the Bangalore Metro's approval, and that condition was the requirement of a comprehensive mobility plan for Bangalore. And through that narrow ground, we've brought in larger constitutional provisions, saying that basically the transport planning in Bangalore violates our rights. We have an Article 14. Article 14 equality right has also, as you might be familiar, interpreted to mean that the state can't do things arbitrarily. There has to be some reasonableness. So the equality provision has gotten fused with a reasonableness requirement, a non-arbitrariness requirement. And so in this case, we've made all kinds of arguments that what's going on in Bangalore with lots of flyovers and more roads, not enough buses, not enough pedestrian footpaths, etc. The urban environment has been the focus here. Is arbitrary. It violates our right against arbitrary action. It violates our right against to the enjoyment of pollution-free air and water. It violates our right to live with human dignity. And this, I've seen so many people in Bangalore really struggling because of the car fetish that our planners seem to have. It violates our right to move freely throughout the territory of India. Okay, I can't be forced to buy a car if I have to get from my home to my marketplace or to my hospital. You should allow me to walk there on a safe road, or you should allow me to take a bus that I can afford to get there. You can't ignore that. These are the kinds of arguments that we have made, and Justice Abhay Oka hopefully will give us some relief on all of this. So I've reached the end of my presentation. Thank you. It went on for way longer than I have planned, but I'll leave you with the inspiration of Buckminster Fuller, which is you never change things by fighting the existing reality. To change something, build a new model that makes the existing model obsolete. And I think it's good time to be building new models for environmental constitutional rights in India. The groundwork has been there, and it's, I think, up to us to think of different ways of taking this forward in our activism, in our litigation, and also in our education and conversations with others. So let me stop and invite comments and questions. Yeah, would anyone like to, I'll be going through the chat box as well, but it would be good if you could unmute and say things directly so we could have a more dialogic conversation.
If you're not able to unmute yourself, you could perhaps raise your hands and I will unmute from my end if there is a technical issue you're facing.
So while folks sort of reflect and maybe choose their comments, some questions that have come to me, particularly the government has given a green light to a lot of eco-sensitive projects without a proper EIA during the pandemic. What are the provisions in the constitution which can help us stop such projects, right? And the immediate answer would be, again, the answer is Article 21, your right to life. And in an interesting decision, the Supreme Court said that the precautionary principle itself is a part of the right to life guarantee, right? So this any such project is basically ripe for litigation, and the way in which I would encourage one to think of litigation is strategically. It has to be, I mean, I'm actually a bit skeptical about courts transforming our social reality, right? So when I encourage people to go to court, I make sure that they are also thinking of non-legal strategies that and tactics that will work alongside the court effort. But someone could very easily go to court against any of these on a fundamental rights violation. More generally, uh, a clearance given is supposed to be challenged by the under the National Green Tribunal Act. So you're supposed to go to the NGT, and this is another part of the complicated reality of India's environmental law. And I should have mentioned this, so thank you. In 2010, under Jairam Ramesh his leadership as Environment Minister, a new institution, the National Green Tribunal, was created, right? The NGT Act of 2010. And basically the National Green Tribunal is the go-to tribunal for 6 legislations, including the important Environment Protection Act, but also the Biological Diversity Act of 2002, the Air Act, the Water Act, the Forest Conservation Act. And unlike your High Court or your Supreme Court, the NGT is interesting because you have like a lawyer person, and then you have like an environmental science, usually environmental science person sitting together and deciding on cases. Its procedures also not as slow as and as bureaucratic as our high courts and Supreme Courts. And while people have mixed opinions, I personally, having studied the NGT over the last 10 years, think that they have the NGT has been pretty awesome for environmental justice in India. Which is why it's no surprise that the government of the day has been trying to really destroy the NGT, including by not appointing judges, not providing funding, etc., etc. And normally, if a clearance is given, you're supposed to go to the NGT and challenge that. But because of the confused state of affairs in Indian law, you can still go to a high court or to the Supreme Court on a fundamental rights violation. The NGT can't deal with a fundamental rights violation. So the minute you say these EIAs being given are violating your Article 21 right to life, or let's say a power plant is coming next to you and you belong to a marginalized community, or you're a Adivasi group that has already faced a lot of discrimination, you can even say it's violating your right to equality, right? And you can bring in these principles that I mentioned, the precautionary principle, the principle of intergenerational equity, the polluter pays principle, uh, the public trust doctrine, etc. So that could be done. Yes, anyone would like to jump in with a comment? Otherwise, I could continue with the chat box as well. But as I said, I think dialogic verbally is always better.
Hi, Abhay. This is Namrata.
Hi, Namrata.
This was a great session, and I was just interested to know if we were to include or mainstream climate change into the Constitution, which one of the five rights that you mentioned would be the appropriate way? Like, should we call for expanding the Article 21 to include right to climate change adaptation, because that is what looks like India's biggest concern for the century? Or should we ask for a separate right altogether, or a duty-based one, like, or a right to nature, as then we could possibly also include climate refugees? What do you think would be the best way?
Thanks, Namrata. That's a great question, and thank you. That allows me to speak about what is presently a passion, which is climate action. So, quick answer, I think all five methods would be useful to deploy. I think the easiest will be the method where climate justice, or the ability to adapt or be resilient in the face of climate crisis and its impacts, or the ability to what you refer to as adaptation, if I may just say it in even simpler words, a right to, in some sense, live in a dignified way, even when my city or village is being pounded by rain, such as that which it has never seen before. A right to live in a dignified way, even when the rivers are overflowing and my home, rural or urban, is flooded, right? A right to a dignified living when the crops I used to grow can no longer grow because it's become so much hotter, or because so many more pests have come, right? I think all of those can very easily fall into your Article 21 right to life, right to dignified life. So that would be the easiest route. The hardest route will be coming up with a new environmental right in the Constitution that will require a constitutional amendment. Constitutional amendments are not particularly easy or quick, and they really require top-level visionary leadership, along with broad-based political support across parties, and also across the federal levels. Um, so that will be the hardest, the method which requires a declaration of a new environmental right in the context of the climate crisis. But I think I haven't seen a concerted strategy to bring in a environmental right into the Constitution through amendment. So the climate crisis provides an opportunity like no other, given that we are in the sixth extinction, and it's as bad as it can get. I think method one continues to be very important, right? Unfortunately, what India goes and says at international discussions is not what the people of India want India to do or say, right? And we don't have these processes of deciding what India is going to say at the Paris agreement discussions. Next year, we're going to meet, all the countries of the world are going to meet in Glasgow for the next COP session on climate. India's stance there has usually been that we are a developing country, we have not used our share of the carbon pie, let us use more of the carbon pie, right? And I have some sympathy for that position, right? I think it's not a wrong position, but there is nothing at the international level when it comes to climate justice domestically. And that's because our right to participate in decision making, our right to how India decides what its nationally determined contributions are, those rights are not being respected. People of India are not being consulted for climate policy. It's all happening very, very secretively, uh, in consultation with consultants, including the GIZ, consultants from the UNDP, consultants from SwissAid, even private consultants that are not developmental consultants are involved in India's climate policy. But India's people are not involved in India's climate policy. So we must constantly, I think, use that first method. Ask for more information, demand a seat at the table, demand the right to participate in decision making, uh, because that battle has nowhere been won yet. I think there's a long way to go there as well. And finally, coming to rights for nature and duties relating to rights for nature, I think those are good cases to take to court, or even good public attention grabbing cases, if you can find some unique elements of India, let's say the Sundarban mangroves, or let's say a particular glacier in the Himalayas. Even better if that glacier is where some god Shiva is rumored to sit or whatever, right? Take that kind of case and demand rights for that mountain because that glacier is melting, let's say, right? That you're likely to get a judge who will be like, wow, this is a case where I can become a celebrity and will give the rights or impose some duty. So I think all five strategies, the easiest being expand right to life to include adaptation to climate crisis and climate resilience.
Thank you.
Hi, Abhay. Am I audible?
Hi, yes, Rajshekhar, please go ahead.
Yeah, hi. Yeah, that was a very helpful, talk from you, because those 5 approaches that are there, as a layperson, it has been quite educating. I have a few questions actually. Some of them could be quite simplistic. One is that is there any environmental watch group which kind of constantly follows up, like there is Association for Democratic Reforms, right, which has a constant watch on every electoral process that is happening in the country. So similarly, is there any environmental watch group? That is my first question, which is following up the so-called development projects.
Sure. So I think there are a few groups that have been doing a laudable job. The ones that immediately come to my mind would be, there is a Coalition for Environmental Justice in India, what is called SEGI, which is a coalition, an umbrella coalition of a number of organizations. I have been a one-time part of this coalition as well. I'm not currently involved with them, but this coalition is quite actively tracking reforms, especially reforms coming from either the World Bank influenced neoliberal agenda, or coming from straight out corporate interest in looting the country, reforms to the environmental law and policy. And the environment support group based in Banashankari is one of the founders of this coalition as well. I think the Delhi-based Center for Science and Environment, though it's not very, very radical anymore, they do keep track, and on their multiple websites, they do point out how changes are coming in, what changes are occurring, how these are good or bad for environmental concerns. I also appreciate the work of a couple of other organizations. So I think Ritvik Datta, who's one of the more hardworking environmental lawyers we have in India, he has a Lawyers for Forests and Environments, a very small group that nonetheless promotes awareness around this. It goes by the acronym of LIFE. I like the Pune headquartered Kalpavriksh, which is an environmental group that there might be friends from there here on this call as well, that doesn't necessarily always take confrontational positions, but brings to light many of the changes and especially the negative changes. So I hope I've given you, and of course, I think the NEPM, particularly given Meda's involvement with a quintessential environmental issue, the Narmada issue, also has some kind of presence and capacity when it comes to monitoring reformative agendas that are coming from a bad place.
Yeah, thanks, Abhay. And you were mentioning about NGT, and I remember that I think it was Jairam Ramesh who kind of made it a mandate that all these rulings have to be made particularly public by putting it on a website. So I know that there was some progress that was done at some point of time, and I also hear from what you said and from the news that NGT is kind of being undermined in a very structured way. So as a layperson, what is it that one can do?
I think many things that one can do, and it all depends on the kinds of energy and the kinds of time frames that one is talking about. So I think the first thing that one can do is exactly what is happening today, which is get in conversation with others and learn more, but also ask specific questions about areas and issues that are of particular interest to you. Sort of building up, I think, community solidarity and building up community itself, for me, continues to be one of the most important things to be done. So I don't know where you live and what you do, but I think if you can build community in your residential area, in your workplace, even within the groups that you are already part of, and build a sense of sharing of information, a motivation towards doing something together, most importantly, being willing to support something when it happens. These things sound like, oh, this is nothing fascinating. I was looking for a lovely answer, but this guy is telling me about like boring things. But this is what really needs to be done, and this is what has only this has resulted in transformation that has been spectacular in the past, right? So I am not a big believer in silver bullet solutions, and I think I do, at the end of the day, I do believe in a small group of committed people having the ability to change the world, and that sometimes requires preparing the ground. So having a community, identifying some common areas of interest, coming up with a process for regular meeting, even identifying experimental issue to take up. Like it could be you take it up by going to court, and going to the NGT is not so hard, right? And just to give you a very practical sense, it might take you time. You might not get your judgment fast, uh, but the NGT usually, it's not like the Supreme Court and High Court. You'll have to wait 10-15 years. The time frame is much shorter. 4 years is usually max for a case going through the NGT. Both in the NGT or in the Supreme Court and High Court, in general, how much does a lawyer cost? Not more than 1 lakh rupees end to end, right? A lawyer will charge about 20, 30. I don't know. I don't want to undermine some lawyer colleagues here who want to charge more than that. But a lawyer, I mean, finding a pro bono lawyer is good. But even a charging lawyer for an environmental case, you can find a decent lawyer who for something like a lakh will get the drafting done and will get the argumentation done, right? So even experimenting, maybe there is a road, maybe there's a garbage dump, maybe there's an incinerator, maybe there's something polluting in your community, and the parties responsible are unwilling to do anything even after requesting and passing on information. A litigative strategy might be worth exploring, and it is common people who are doing all of this, like this metro case that I mentioned to you. The petitioner there is now a trustee of the Bangalore Environment Trust, but most of his life he's been working as a professional in a company, right? So now he's feeling like he wants to get more involved with public interest litigation. And I think it is through this, learning, connecting, solidarity, finding community, and then occasionally taking concrete action. That action could be litigation, but that action could also be something like, I'm a big fan of the transition town movement, and here you have small towns and parts within cities where communities come together and actually change their neighborhood, right? As part of my nonprofit, the Initiative for Climate Action's work, we want to experiment with the transition town model in Bangalore as well. Might take us some time, but how nice it would be if I live in Coxtown. How nice it would be if the rights of nature were respected in just Coxtown, where, let's say, stormwater drains were properly maintained, the water was allowed to go into the earth to renew the aquifers, pollution and polluting industries were stopped. Even the social side of vibrant environmental systems, locally produced food, handicrafts, goods. So one can imagine all kinds of possibilities. The imagination is first, and I don't think anything is impossible. I think the common man can do everything with other common men and women.
Yeah, thanks, Abhay. And yeah, since you were also mentioning about the silver bullet, somewhere in the passing during the talk, you talked about you not being a very strong believer in legality changing the social reality or something on those lines. As somebody who has been working here, just so that it might be helpful to some of us to kind of be more rational in one's approach or expectations. If you can throw more light on that, that would be great. And that was my last question. Thank you.
Thank you. So okay, I don't know if I have a clear answer. I'm a confused lawyer, my friend. So that said, my own study of how courts work hasn't led me to the conclusion that courts actually transform society. So I don't think a judgment from the Supreme Court or the High Court changes what people and non-human life actually encounter. There are many sort of interim stops from the judgment to a transformed reality. So rather than say that I don't believe in the value of going to court, let me say I think that being really strategic about litigation is important. And let me explain this through an example. So one part of my work again with ESG about 7-8 years back was with relation to lakes in Bangalore. And we secured a very good order from a very good judgment from the Karnataka High Court, which said a lot of useful things when it came to the protection and preservation of lakes, including how all the lakes will be surveyed, how a participatory system will be put in place to ensure that local dependent communities will also be included, how lakes will not be very quickly sort of privatized or surrounded with a wall and a ticket, right? Lots of good things came. But just the Karnataka High Court saying that didn't change the state of lakes in Bangalore, right? So the what some people don't realize, and this is what I have to tell some litigants as well who are very enthusiastic about turning up in the newspapers because they will be reported in the newspapers, is if you're actually interested in change, you have to constantly mobilize. You, even after you get the judgment, you have to send the judgment to all the people who are required to do something. You might have to go back to court and say this particular officer is refusing to follow the judgment. You need to educate people. Let's not assume to malice that which might be due to lack of awareness, right?
Yeah.
So there is a lot of, you need to also, outside of the court system, and this might happen even during litigation, you might need to actually use other kinds of strategies. And let me come back to the Mavali Pura case. So in the Mavali Pura case, one day I'm sitting in the Karnataka High Court in the Chief Justice's chambers, and suddenly about 25 people from Mavali Pura come into that court. It's a small court, if you might know. And they're all carrying bottles of dirty water, and they're waving it like that, right? So it became a proper tamasha that happened in court. And that was not a legal strategy, that was a political strategy. It was a strategy that the DSS and ESG together came up with, and it worked, right? The judge felt a bit, I don't know, maybe the judge would have done whatever he was anyway going to do, but we think it made a difference. And these small things matter, getting journalists to report on something, having people actually present in the court on that day, getting other people to take the judgment to their own context. So I think what I'm trying to say is it's not a quick, you get the judgment and environment is saved kind of equation. It requires a long-term strategy, long-term engagement. And before embarking on it, it's useful, in my humble opinion, to prepare for that, to prepare for assuming we get the good judgment, how will we actually get it implemented?
Yep. Thanks, Abhay.
Thank you for the questions.
Okay, Abhay, this is Vinay. I have a couple of questions. One quickly on the aspect. I, in fact, put it out on the chat. Maybe I'll just read that as well. So of late, we've seen a very simplistic approach to environment conservation by just using afforestation as a go-to solution, right? So what is a strategy that we can adopt to bring in sound ecological judgment into these kind of grand schemes? Like recently, Prakash Javadekar has committed to restore 26 million hectares of degraded land. So that sounds scary now. If the government simply wants to go plant trees all over that place. That is my first question. And the second question was related to the transition town principle. Sounds really interesting. And one comment on that is, how useful do you think would it to perhaps do a survey survey at a ward level in a city to understand which of these wards are already compliant to a certain standard? That if suppose there's a golden standard, just can we measure each ward and say, oh, some wards are already perhaps compliant, and then use that as an example to push other people towards better behavior?
Thank you. Great questions. Let me just start off with the second one first. I think it's a great suggestion, and in fact, a few groups have begun this work, and I would just use this opportunity to mention a group called Sensing Local that has done very good granular ward level work in the city of Bangalore when it comes to municipal solid waste management, right? The group, Environment Support Group that I mentioned, has also carried out a ward level survey of people's perceptions. I don't know more specific details. I think groups such as Reap Benefit and the group called Civic with Katyayani Chamraj are all interested in this discourse around, bottoms up, truly decentralized decision making. And I don't know if you all have been noticing, but around COVID time, everything went to the wards very fast, including ward level COVID officer, right? But on all other matters, the challenge of getting our wards in the city of Bangalore activated has been slow. It has been resisted. Even having ward committee meetings, I don't know how many of you all are members of Citizens for Bangalore. I count myself as a member of Citizens for Bangalore. They've done good work in making ward committee meetings happen. And they are happening in many wards, not in all wards. So I think it would be, Vinay, a great idea to work with some of these groups and to identify, uh, uh, based on what some of these groups have done, sort of good wards where already a lot of spade work has been done. That will just make our job much easier. And I don't know, I can't claim to know Bangalore as well as I should. Maybe there are others here who know more. I suspect though that within the wards in Bangalore, there are already some clear winners when it comes to environmental justice, sustainability, and broadly environmental thinking. And I'm cautious here to sort of point out, middle class and upper class aesthetic versions of an environmentally beautiful city will quite often uh, threaten uh, marginalized and vulnerable communities' environmental rights to use the city as well. So it's a politically fraught terrain, but I suspect there are already some neighborhoods and wards in Bangalore that are doing a good job, and I would be delighted in actually learning more about this. On your first question, there is no easy answer. It's much easier to ignore the science and come up with some ham-headed policy that allows you to score some brownie points or allows you to make money or use your discretion later, right? It's not like environmental scientists haven't been trying, and it's not like uh, I mean, I personally have a grouse against environmental scientists in India. I think uh, I can count on my hands the scientists who have actually had a spine to speak up against the government. Okay, this is they're at another world compared to other countries, and maybe I shouldn't be so mean. Maybe jobs are at stake, so on and so forth. But I haven't seen too many environmental scientists who have pointed out the sort of huge problems in environmental policy that the government brings out. But even when environmental scientists give inputs into policy processes, these processes don't accept them. So it's not like Javadekar doesn't know uh, uh, how biodiversity is a critical element of environmental resilience, right? It's not about only number of trees. It's also about the diversity of trees and the diversity of life that depends on that diversity of trees. Uh, but it's easier to ignore that, and therefore I think finally it always has to come back to uh, constantly and fearlessly pointing out that uh, the whatever emperor has no clothes. This is absolutely ridiculous. This cannot be the best that this country can do, because I have seen in the past quite often that great inputs have gone in, but they're just not considered by the uh, governmental authority that's responsible for coming out with the policy. And the solution to that is point out how it's a sham, meaningless public participation exercise, and then really critique the policies when they come out through all formats available, by going to court, by writing in the newspapers, by speaking fearlessly to each other. Uh, and the hope is you will find allies there. And I don't think all politicians are bad. I don't think all bureaucrats are bad, right? The current climate is such that even the good ones don't feel confident to do what they think is right. So if you want transformative change, it's necessary to find these allies and keep building up solidarity. And if you are not fearless, if you think you can state your opinion either in the the press or even in public forums, you should.
Right. Thanks, Abhay. Purna, you want to do a time check? I think we are.
Yeah, I was just going to say after he responded to this question that we are at 6:02. If there are more questions, we may perhaps extend by a few minutes if everyone's okay with it. More importantly, if Abhayraj is okay with it.
I am okay. I've just got a couple of private questions from folks who wanted the slide deck. So Purna, if I email it to you, and if folks who want the deck email Purna, that's how we could make the connection happen.
Yeah, we could do that.
Unless I can drop it in here. Can I drop it in here?
Yeah, you can in the chat box.
Oh, I can. Then I'll just do that. Yeah. There we go.
Okay, Shaili Basu had a question apparently that we have. Was it the question about organizations in Bangalore, Shaili? Or before that you asked if courts can be approached for violation of right to life if there are instances of large-scale deforestation taking place in a particular area? So I don't know which one of the two you're referring to. I just assumed, given his responses, some of it was answered because he listed out all the organizations that have been working in Bangalore on the environment. But
let's not forget Alternative Law Forum that I did not mention. The original good force. So yeah.
right. So thank you, firstly. But okay, yeah. So you have had your question answered. Thanks, Sherry, for your questions. So Abhayraj has put the PPT in the chat box. But if there are folks who are not able to open it, which is sometimes the case, you can privately send me your email IDs and then I will forward them to you. You can try downloading it from the chat box. Right, maybe we could spend, or maybe we could give them 2 more minutes to let us know if you have any more questions or comments, after which perhaps we can close the call.
Sure. May I also just use this opportunity to make a pitch for the Initiative for Climate Action? We will be sort of carrying out a lot of work around transformative climate action, climate justice, and also climate litigation in the months and years ahead. So do get in touch with us in case you'd like to be involved with our activities.
Thank you.
Hello, sir.
Yes, go ahead.
I have a question on River Yamuna and Ganga have the rights from the Constitution, right? What are the major reasons to have the rights to the rivers? Can you elaborate on it?
Thank you, Mamta. The reason it's not a simple question. Why rights exist are to protect interests, arguably, right? I have a particular interest. I have something that is valuable or good, and a right is a moral and a legal concept that protects what is valuable or good, right? That's how the idea of a right might be explained in sort of very simple terms. A right allows me to then make a claim. My interests are not protected. What you're doing is hurting this interest, right?
Yes.
And so rivers having rights are part of a sort of longer journey in law where non-human entities began to be recognized with rights. It could be corporations. Companies have rights. Companies are legal entities. Companies can sue and be sued in court. In some countries, gods have rights. They have legal personality, if not rights. they can own property, and we've seen how legal entities of divinity are being used in the present moment, not in the interests of justice. So in the history of law, rights and legal entity moved from human beings to artificial entities, if you wish, like companies, like gods, like other kinds of collectives. And starting with a sort of seminal article written by Christopher Stone in the 70s, should natural objects have legal rights? There's been an increasing recognition that even non-human life should have the same idea of rights. It could be an animal, so animal rights comes in. It could be a bird. It could be a plant. It could be an entire landscape. It could be a forest. It could be a lake. It could be a water body, right? And though the law is very recently tracking this, in both indigenous knowledge and in spirituality, for the longest time, nature is alive. Some Sherpas, for example, will not climb some mountains because they believe that the mountain is their god, alive god, right? Many other indigenous communities think of a lot of nature as being alive. And once you're alive, you have rights, you have duties, you have responsibilities, so on and so forth. So to cut a long story short, rivers have rights in Indian law because when a case went to a judge in Uttarakhand saying that the Yamuna and the Ganga are very polluted, that judge found it useful to give the rivers rights because he thought that that would make sure that people actually prevented the pollution of the river. So it was a strategy of desperation almost. Otherwise, the Yamuna and Ganga have been polluted for so many years and so many crores have been spent, nothing seems to work. So maybe if I give them rights, people will start taking them more seriously. Maybe the pollution will stop. So I hope I answered your question in some manner.
Yes, sir. Thank you.
Thank you for the question.
Right. It's 6:10, so perhaps we will end the call now. Thank you so much, Abhayraj Naik, for joining us today. It was a very good session looking at the historical development of environmental laws and great reading material that gives us a constitutional basis on which this jurisprudence has been developed. Thanks also for patiently taking all the questions. Hopefully we can have you with us in future to carry this discussion forward. Thank you so much. Thanks also to all the listeners who tuned in on a Sunday evening. Thank you so much, and hopefully we'll be able to continue our engagement with the Constitution on different fronts. Thank you.
Thank you, Purna, and thank you to Vinay for very kindly sharing the readings. Yeah, a lot of people helped in making this happen. So thank you to everyone.
Thank you. Thank you.
Bye. Good day.
You too. Bye.